right, Ms. Baldwin, your motion for summary judgment. I have read the pleadings and I'll turn it over to you.
I do have some preliminary
Oh.
objections.
Okay, yeah, I just, yep.
Mostly based on time. As
Yeah.
the court's aware, the motion was originally not set right. The timing was not enough time to have it be heard on the 28 days. We appear to have remedied that by setting it over. However, there still is the issue that there was new information provided in the last statement. The other thing is the court rules are very, very clear on motions for summary judgment that it must be 5 days before the hearing. Obviously the hearing is today. We only received this 2 days before we received it on Monday. So I would ask to strike the responsive pleadings of Mr. Crippen because they don't comply with the very, very strict motion for summary judgment rules under CR 56.
Ms. Baldwin.
So number one, the time to ask for continuance is at the beginning of this docket when the court asked for those items. Number two, we set this over because they had filed late. And so we set it over last week. Essentially, we didn't have those 5 days even possible. And so provided the materials as soon as as soon as we could, based on when we were served the response. And the original timing, I think, was 2 days shy, just because of how it was served, and we did cure that by setting it over. There's nothing to do with a reply. And so based on the fact that they didn't ask for the continuance earlier, we should go forward, and there's really no basis to strike the materials.
Okay. Ms. Winkles, I'm not going to strike the reply, but so I guess I'll turn it back to you to see if you feel that you need additional time to respond.
No, Your Honor, if I can just, I think most of the things are actually in my client's declaration. If there is a new claim that wasn't claimed in the first one, I will be highlighting that and bolding it and asking Your Honor to strike that sentence anyway. And that way we can continue forward today because I think it's just a judicial economy.
Understood. Okay, Ms. Baldwin, go ahead.
All right, thank you very much. So in this case, I represent the respondent. This is our motion for summary judgment as well as for a frivolous finding. The underlying claim here is for a committed intimate relationship or a CIR. And in this case, when we're looking at the evidence that both sides presented, my client presents his declarations and the exhibits attached thereto, as well as many, many, many community members who also provide their direct recollections of both parties. The petitioner only presents herself and her child as witnesses. And her child really lacks any foundation for her statements. There isn't any, I know this because I was there. These are just basically, well, my mom told me, and so that's where my information comes from. So the single witness she has is really somebody who doesn't have the foundation for the information other than my mom told me. In these types of cases, summary judgment is important. Although we recognize that there is a burden to be met here, summary judgment is important because it deals and ends cases and controversy that don't have merit and that are extremely costly to parties to resolve at trial when there really isn't a genuine issue material fact. And that's really the question here is, do we have that genuine issue of material fact based on the claims that they have made? And genuine doesn't just mean I've thrown a fact out there. It cannot be facts that are provably wrong or facts that we know are perjury because we have earlier sworn statements. They have to be genuine. And does the law support that? Even if everything they said was true, does the law support their contention? And in this case, the petitioner's claims fail on both accounts. They do not have the facts to show a committed intimate relationship, and the law does not support their action based on the facts. So what are the facts in this case? When we look at the facts, we have my client purchasing a parcel in June of 2021. That parcel had a home on it. The petitioner comes to live on that parcel effectively a year later in May of 2022. And she lives in an RV on that unit, or on that parcel, not in the house. And this is based on her own declarations. Now she says 2021, but she admits that she came to live on the property at the same time as her son's wedding. And we have the wedding invite that says that was 2022. So we have, again, something that she says, but her own words belie that, as do the facts. So she's provably wrong. She's off by a year. on when she came to live at the parcel. So this is a provable instance. We also have that she left in December of 2023, 17 months later. And again, her own declaration. So her claims are 2024. That doesn't match with her own declarations that say 2023 from earlier in the file. And again, we have that the petitioner owns 2 separate parcels of her own, not connected to this parcel. She owns 2 pieces of property in the Vancouver area. And so this isn't some situation where she doesn't have anywhere to live or something of that nature. And she lived at those parcels through 2021 and into 2022 until she came to reside on this parcel in the RV. Between these parties, everyone agrees and there's no dispute. There are no joint accounts. There's no joint debts. There's no joint obligations. There's no financial ties between these 2 parties. We don't have 2 parties that have both names on the mortgage or both names on the deed. We have none of those sort of critical elements. And it's also important to note that the petitioner in this case admits that she paid rent to my client, which again, when we're looking at the relationship of these parties, is that meretricious or is that landlord tenant? And so again, she admits in her own declaration that she paid him rent. We have multiple witnesses who say petitioner dated other people, that she was seen with other people, and same as to my client, he dated other people. And neither party really contests that either. And also those same witnesses said that when these parties were asked, hey, are you a couple? They both adamantly disputed that. They both said, absolutely not, never again, never going to do that. So these are the facts that are provable in this case, or that are directly established from petitioner's own statements or her own materials. So looking at a CIR in Washington, the old words for this are a meretricious relationship or a common law marriage. But the key is that it's marriage-like. All those words roll into, it looks like a marriage. It sounds like a marriage. It feels like a marriage. And the law really breaks that out into kind of, here's what you need to look for. These are the things that make it marriage-like. And the first condition is there's continuous cohabitation. And we don't have that here. The very word defined, cohabitate, means to live together in a dwelling. And these people didn't do that. We have Mrs. living in the RV, which she admits in her own declarations, and Mr. living in the home on the property. So 2 separate dwellings on the same parcel, but again, 2 separate dwellings where they lived. If you were going to take some kind of wild expanded view of cohabitation, then everyone who lives in an RV park is cohabitating because they're on the same parcel. And again, that just stretches logic. It just doesn't make any sense. And so again, they do not have this element. They do not have cohabitation. The next question is duration. And this is a duration of just 17 months, very short. So when we're looking at duration is a factor, but often when we're looking at, is this a meretricious relationship? We're looking at, hey, these folks never got married, but they were together, living together for 20 years. You know, we have these very long timelines. 17 months is roommate timelines. It is not marriage timelines. It is not marriage-like. And again, the 17 months is based on her own documents, on when she says she moved out and when she says she moved in. And when she says she moved in is the same time her son got married, and we have the wedding invite that says this is when that happened. So again, not marriage-like. They don't have this element. The next element that the case law tells us to look at is, what was the purpose? And again, the purpose was not marriage. We have statement after statement after statement from witnesses who say these folks adamantly denied that was the purpose, that they were not together, they were not a couple. And so again, we don't have that purpose. And similarly, when you look at, well, was it marriage-like? Were they sharing everything? Was this sort of my stuff is your stuff and we're living together? So again, no, we don't have that. We have her paying rent, him demanding that she pay him back for things that, hey, I advanced you some money there, you need to pay me back. That's not a share and share alike relationship. So again, we don't have something that is marriage-like. These parties say, hey, the idea was we'd live nearby, I could give her a ride, and essentially sort of this friendship type relationship where it was convenient for both of them, but there are no promises here. There's no guarantees here. There's no, when I die, all my property goes to you, I'm going to be there till the end. None of those promises between these two folks. And that also leads into the question of, is this exclusive? Frequently cases look at like, it has to be marriage-like, and marriages are exclusive. And we don't have that here either. That's the element of committed. They have to be committed to each other. And to some degree, it has to be committed in an advanced way that you're not just friends. Friends can be, I'm committed to you as a friend. That doesn't make it a CIR. And so in this case, we clearly don't have that. We have both of these folks dating multiple people throughout this 17-month time period. We have the declaration of the fellow who says, I was dating her. And so again, we clearly don't have something that's exclusive, and she doesn't deny that. She doesn't say that it was exclusive whatsoever. Next element is pooling resources. And again, we don't have that. No joint accounts, no joint debts, no joint marriage, no joint liabilities. We don't have anything here where both of these parties' names are on any type of financial account or piece of property whatsoever. And in fact, what we have is exactly the opposite, completely separate finances. And that is not marriage-like. At best, she says, well, I ordered some stuff on Amazon for him. And that doesn't make it marriage-like. And especially when my client says, yeah, but so did Bobby down the street. He says, yeah, but I did that with several of my friends because they had Amazon Prime and I didn't. That made sense. And I paid them back like I paid her back. So again, this isn't marriage-like. That isn't a situation where he was on her Prime account. They shared a bank account. They shared a debit account. They shared a credit account. No, none of that. So again, this is sort of friendship and people helping people, but it isn't a marriage-like situation. And again, looking at the intent. The intent here was to give rides, to be friends, check in on each other in the same way friends would, in the same way that you might check in on a neighbor and make sure that their newspaper, their mail got brought in. That doesn't make the intent here marriage-like. And in fact, both parties, again, disclaimed that to many, many witnesses saying, absolutely not, we're not together, we're not a couple, we're not a thing. And so again, the intent here was not something that was marriage-like. Now, when we really look at the law, a CIR is a heavy lift. We're trying to say you were married. You were married in everything but name. And that is a huge commitment. Marriages are contracts, and they come with a whole body of law and obligation, responsibility. And so it should be a heavy lift. And here they have not met that burden. When we look at the cases that I cited that kind of go through looking at what qualified for a CIR and what didn't, when we look at the Connell case, again, the parties didn't contest that there was a CIR. So in Connell, we had parties that kind of basically admitted, yeah, there was. We might dispute when it was, but ultimately we were doing things together. We were planning to have kids together. It was everything that was marriage-like. Similarly, with the Lindsay case, these parties did get married. And so similarly, the question is really, well, was the time period before the marriage-like? And again, so the intent becomes much more clear because these folks did get married. That is what they, somebody put a ring on it, somebody was engaged. There was clear time periods where that intent wasn't fully intact. But again, we don't have that in this case. This case is much more analogous to the Pennington case, which is really the only case that really showcases sort of a contested CIR where one party says, no, this was not, I did not intend to create a marriage-like relationship. And the court really sort of drilled down on the intent. Was the intent to create something marriage-like? And in that case, the court says, no, there's not sufficient evidence to support a CIR. And that's really what we have here. We have none of the hallmarks of a CIR, and this is their burden. And in fact, that case mirrors this case in that the fellow in that case adamantly refused to marry the other party. And that's exactly what we have here, is where the parties say, absolutely not. And in fact, both parties in this case said, absolutely not, we're not getting married. And so again, that really negates this CIR claim. I would argue, again, when you're looking at the law, what they're really trying to argue is for a massive expansion of CIR and what it means that's fully unsupported. essentially a friendship relationship can become a CIR if the court was to find that this was a CIR. And that's really what they seem to be arguing, is that, well, hey, we lived next to each other and we were going to take care of each other and we were friends, and that's enough. And that isn't supported by the law. The law does not say that's enough. It has to be marriage-like. It has to have all those hallmarks. These have to be people who live together in the same dwelling. They were sharing resources. None of those hallmarks are here. And they just want to expand the definition, grossly expand it to basically include friends who are just being kind. So again, that's fully unsupported and arguably a policy disaster should the court grant it. So once we get to this point, we realize that when you look at Rice v. Offshore, in that case, the burden shifts. The burden shifts from my client to them to be able to prove their case and say, hey, you've got to show you were marriage-like. And they have not done that. What they've argued is for a departure from the law, but they have not met their burden. And again, it has to be more than sort of self-serving statements. And we really don't have that in this case. And so because we don't have that, because we don't have the facts that support a CAR, sort of the bare bones facts aren't there, and the law that they're arguing is, again, for a huge departure, this is frivolous. And so this is a frivolous case because the facts don't support it and the law doesn't support it. And so frivolous is appropriate in this case. And so my client, with the finding of frivolous, what my client receives is his attorney fees. And so we are asking for his attorney fees in this matter. Essentially, this was somebody who lived on his property, paid rent, they were friends, she moves away, and then instead of picking up her stuff, she starts this whole case. And that isn't appropriate. And so again, we're asking for that frivolous finding, as well as the court granting summary judgment in my client's favor.
Thank you. Ms. Winkles, go ahead.
Yes, Your Honor. This is a difficult one, and essentially we're here today on two things that we need to keep in mind: the motion for summary judgment and the sanctions, and both of those must be denied. Just looking at summary judgment law to start with, CR 56C is very clear that there has to be no genuine issue as to any material fact, and the moving party is entitled to a judgment only on that basis, and that's the Seven Gables case. And the thing that needs to be essentially put forward is that all facts are in the light most favorable to the non-moving party. If reasonable minds differ, then under the Vallingham and Clover Park School District, it's inappropriate to have a summary judgment. Any dispute of material facts defeats a summary judgment. Frivolousness law, RCW 4.84.185, allows sanctions only where there is a claim that cannot be supported by any rational argument on the law and facts, and that's Biggs and Vale. And it's D as a North Star reiterated that. There's a ton of case law that reiterates that sanctions are improper if any rational argument exists. They resolve doubts in the court against frivolousness, and that's Alexander and Sanford. And so now let's move on to the CIR law. Essentially what it is we look at the Connell and Francisco. Property acquired during a stable marital-like relationship in which the parties cohabit knowing a lawful marriage does not exist is subject to just and equitable distribution. And then we have the Byerly and Kale non-exclusive factors. Again, non-exclusive factors. So I want to kind of go into those because there's sworn declarations, there's exhibits, there's respondent's own statement. And at a minimum, the record provides that there's multiple genuine issues of material fact. But I want to kind of go through what some of these things are. If we look at Connell and Francisco, we find that the parties cohabit knowing that a lawful marriage does not exist. That's the first one. Byerly and Kale, continuous cohabitation, duration, purpose of the relationship, pooling of resources and intent of the parties. For this case, if we look at Meridian and Radel, which I can't say, they squarely held that the word intimate is not intended to make sexual intimacy the litmus test, which is what they're basing their whole argument on here, is that the central argument, there's no CIR because there's no intimacy, there's no sex, there's no hand holding, is essentially a legal non-starter. They've rejected this, Washington, over and over again. They've rejected it outright. We're looking at whether their conduct was marital-like. So if we look at essentially the facts of it, and we look at what does it mean to cohabit? So just starting on cohabitation. Does it mean that, or I guess cohabitation does not mean the same bedroom or unit. It means a shared domestic life, which the record proves. First off, you have to look at the individuals here in specificity. My client was going through chemotherapy at the time. My client had part of her intestine removed. The idea that these two parties were not intimate because they didn't have sex is ridiculous. This is a woman going through chemotherapy. The idea that she slept with everybody and anybody is frankly ridiculous as well. And how do they support that? They support that with declarations from essentially barflies, people at a bar that they occasionally frequented. They didn't live at the bar. They didn't spend time at the bar. That was more than any other time spent at a normal establishment. They did not live there. They did not spend nights there. They did not essentially have these people into the home. These people all stated in their declarations that they knew what they knew based on being in that bar. The fact is if we look at the CIR test, they're non-exclusive, non-hypertechnical factors. No one single factor controls. No one factor is more important than the other. Washington courts is assessed for continuity, publicity, and permanency of living together, not whether they slept in the same room. There are a lot of married couples that do not sleep in the same room every night. You can look at Birchfield and be Birchfield, which means cohabitation is living together continuously, publicly, and some degree of permanency, some degree. Marriages end as well. And this was actually quoted in the Division I case in 2025. They've squarely rejected, like I said, the intimacy test. And I mean sexual intimacy. I don't mean intimacy. If you look at the text messages, you will find that these are two people that spent almost every night together. I don't know of anything more intimate and more marriage-like than watching NCIS together on a weekly basis. That's what these two did. This is not for rides. These were people that ate together. These were people that watched TV together, that shared their fears and shared what they wanted, and shared their dreams for the future together. If we take the respondents not sharing the same dwelling, it misstates the law and the fact. My client slept in the RV because the respondent delayed ADA modifications. That doesn't defeat cohabitation. The fact is that the entire situation looks like a marital-like domestic establishment. We have daily life, we have utilities, we have repairs, we have finances, and we have presentation to the world. It's not rigid. They cohabitated in the house for around a year together. And the fact is that cohabitation was something that we can see from his own text messages. He talks about taking a shower, putting up drywall in her room in the house. We then have her essentially staying in the RV because it's the only ADA compliant. He says he's going to fix up her room. He's going to get it ready for her repeatedly. But did she bathe in the RV? No, she bathed in the house because he even says he wants to make sure that she's bathing while he's doing painting. So if he slips, there's somebody there. Now, did she get the year wrong? Yes, my client has significant health issues and it's probably more or less a typo. But the fact is that they spent the majority of their time together and cohabitated for over a year together, sharing the house, with her bathing in the house, eating in the house, and all that. And you can see that on my client's declaration, page 5. They also coordinated household utilities and repairs together. He states, put the PUD in your name tomorrow, please. Then I'll have the heat pump worked on. We'll work out property taxes and insurance. These are capital issues of money. These aren't, I need rent. These are issues of property taxes and insurance are essentially go to the capital value of the asset themselves. This is not something a tenant pays. These are things that the owner of the property pays. And it's interesting that you'll see in Exhibit N in his own words, him talking about her contributing to this asset, the house that they bought together. They even went to find this house together. This was not a simple, I bought this house, come on over. This was, do you like this house? Are we going to live together in this house? What are we going to do with this house? He then discussed the mortgage payment and household expenses with her, taxes, insurance, electric, on page 24 of my client's declaration. He even says, talking about the other personal property, get insurance on the Jeep, please. page 24 of my client's declaration. Again, he referenced work in her room. Tomorrow when you take a bath, I can do some sheetrock in your room, exhibit M. The entertainment and routines they shared as a couple. Did you watch the Mine Hunters? When was the last time we watched it? And she talks about being sick. And he says, well, I watched to the end of the one you fell asleep to. That's page 19, exhibit E. That is more intimate than sex. She falls asleep on the couch next to him. He's watching TV. He goes ahead and finishes the episode that they were watching. These contemporaneous communications, which are more than these declarations from barflies, they show a single domestic unit on a single parcel. They show utilities in my client's name. They show repairs planned. They show planned and paid for ours. They show bathroom use in a house. They show the room in the house being finished for her. They show joint routines. This is precisely living together publicly with a degree of permanency. And that is what Washington law equates as cohabitation. If the respondent now claims she only lived in the RV, that's belied by those integrated household facts that at a minimum, those text messages create a genuine dispute of material fact that would have to defeat summary judgment. Because again, if reasonable minds could differ, then summary judgment is improper. To the extent that the no intimacy, no CIR, we have to figure out what we mean by intimacy, because are we talking about a sexual act or are we talking about a lot more than that? Under Connell, Long, and Fragile, and under the Murian case, we're talking about a host of other things that are intimate. We're talking about marital-like conduct, household integration. Can you move your stuff? Shared entertainment, dedicated room in the house, repairs, tax planning, vehicle insurance. I'm going to buy you a gift of a car because you've always wanted it. That's not something a landlord does to a tenant. And as you see from those text messages, she does something wrong during the relationship. She essentially flirts or kisses another man at the bar. And what happens from there is Mr. makes it a tenant relationship. By the way, you kind of owe me. Not you owe me, not we have a loan. You kind of owe me. So I'm going to change the nature of our relationship now that I'm mad at you. But that is not what the parties intended at the beginning. It's clear from my client's declaration, it's clear from the daughter's declaration that he said he wanted another shot at taking care of her. He wanted another shot at being the husband he should have been before. He took a very ill woman, moved her onto the property that they picked out together, fixed her room up, had her come in, watch TV, eat with him every night. He inquired about her health every day. She inquired about his. They inquired about the cats together, the dogs together that they shared. And this is an incredible amount of intimacy. We can't judge this relationship by some movie idea of what a relationship looks like. That would be absolutely wrong, because Washington law does not require proof that they slept in the same interior every night. It doesn't require any of that. What it requires is exactly what those texts share, which is cohabitation outright. But at a minimum, it's something that creates tribal issues of fact that need to be essentially reviewed by a trial court. We then look at the pooling of resources. Now, counsel stating that there was no pooled resources, that they didn't share anything, but pooling of resources does not require joint debt, joint bank account. What it includes are shared bills, purchases, and services, all of which the record shows. If you look at the actual law, Washington courts evaluate pooling of resources and service for joint products by the Connell factors, and it's nothing really controls. If you look at Ambergy and Bulk, which is looking at credibility issues of what was actually done, that was absolutely an issue for the trial court. And Byerly and Kale, it confirms that pooling is shown when the expenses and efforts, not just the money, are shared in ways inconsistent with arm's length business-like relationship. Arm's length business-like relationship. We have him buying a Jeep. We have him putting the Jeep in her name. We have him buying an RV. We have her contributing her time and effort to fixing it as much as a woman going through chemotherapy can. We have him buying a house and then fixing up her room in the house. He doesn't ask for money. Again, he only starts asking for rent after they start fighting. But we have her buying things too, providing him dinner as well. providing him a good time, saying everybody misses you when they do finally go out. So the legal question is not, do they have a joint bank account? The legal question is whether or not they pooled money, labor, or services to run a shared household and accomplish joint projects. Connell expressly includes services, meaning labor, caregiving, and domestic work as part of pooling. And the fact is we have utilities, repairs, ours, we have the text from the respondent, put the PUD in your name tomorrow. I'm going to have the pump worked on, and then we'll talk about the property taxes and insurance. He also talks about the mortgage payment, and he talks about the Jeep, get insurance on the Jeep. We have household purchases and reimbursements, shared consumption. We shared purchases like Amazon, and you see they shared an Amazon account. Now, while council may think that's not a big deal, to allow somebody to have an Amazon account where they can essentially buy whatever they want, and they buy it for the joint consumption of the house, that is a very intimate thing as well. We also have labor and services for joint projects. We have the ADA room. He doesn't need an ADA room. That room is for her. We have repairs and daily domestic life. She says tomorrow when you take a bath, I can do some sheetrock in your room, again, Exhibit M. We also have, did you watch Mindhunter since we last watched together and you fell asleep, Exhibit E. The petitioner says, we are renovating your room. You're bathing in the house. They're living and doing the same daily rhythm, service and domestic work, all of that stuff together. My apologies. My son has an emergency breakthrough on my phone. I apologize.
No, you're okay. Go ahead.
We have all of these things that are absolutely showing that they have a CIR. And the fact is that if this is a credibility issue, it is 100% an issue for trial. She says, well, it's only her self-serving declaration, but it's not. It's text messages between the two of them. It's the daughter on a third party saying what her mom was expecting from this. They were expecting to live together for life and to take care of each other until they died. There is nothing more intimate than that. If we look at, applying pretty much everything that we have, the text messages themselves are really everything here. Because these text messages, you can see him getting angry when what happens. You can see him saying, I love you, and are you okay? And all these things, and like, are you mad? Are you mad at me? And she said, I need some time. And he essentially is like, well, he starts to get drunk and he starts to drink. And she starts to talk about that. But what we see for the first year of this relationship is quite possibly one of the best relationships that we see in family law. They're really supporting each other. They're really helping each other. It's when she makes a mistake that she, quote unquote, cheats on him, that he starts being angry and starts asking for money. We don't see any texts asking for money before this 2023 issue. Additionally, you'll see the transcripts that we submitted where he calls her my girlfriend to Terry. The fact is that he thought that's what they were. They have more of a marriage-like relationship. It's not, there is permanence. The permanence is death. The permanence is I'm going to be the husband that I'm always going to be. We can't use the duration of this marriage as controlling because frankly, it is a one factor. We have to look at what the parties intended. And if you're going to build out ADA, if you're going to share in this domestic routine, if you're going to do all of this, then you're expecting a duration to be long. And the fact is Washington law rejects a minimum months rule. Absolutely. They examine everything by a totality of the circumstances. And we have robust evidence here. As a matter of fact, the record supports well over a year of co-living on the same property with these integrated household functions. There's a reason Washington law doesn't state 7 years. There's a reason Washington law doesn't state there has to be a certain amount of time. That's not what this is about. And the separate finance issue does not carry the day. The fact is that you have large capital items of relationship investments, gifts, not loans. Lance, let me help choose the RV and paid $6,800 for it. It was part of his love bombing to get me back. He bought an RV just so she would have ADA accommodation. There's never an agreement of loans. You see him unilaterally call it a loan later on when he gets mad, but you don't see their gifts. To be close to him and live out her days with him. She never asked for the RV. She never asked for the Jeep. He gives those to her. Those in-kind contributions and gifts are classic pooling under Connell. You don't negate pooling by calling a gift a loan after the relationship soured. You can't do that. The utilities in her name, the vehicle insurance, the mortgage discussions, all of the stuff about what I should do, what I should buy. He is essentially talking to her about it because he wants her input because these are for both of them. The tenant theory versus the pooled household reality, the texts are opposite of a landlord-tenant relationship. A true landlord would send rent invoices for space. He'd not ask a tenant where he lived on the property as well to put PUD in her name. He would not coordinate fixing a heat pump with her or to work on property taxes and insurance tomorrow. These are household conversations. These are not arm's length tenancy. I'm going to add sheetrock to your room, bathe in the house. Places are inside of the house, watching TV, falling asleep on the couch. These are not tenant theories. These are definitely pooled household theories. Bottom line is for CR 56, even if he continually exists, we kept separate accounts. The legal standard and the records show abundance of a pooling of resources and services. Reasonable minds could differ, and that's fatal to a summary judgment. There's conflicting evidence on a lot of this, but what my client has are the text messages showing this care, showing this intimacy, showing that all of this was supposed to go on for a long time until he got mad. This is absolutely not a Pennington case, because what Pennington actually says is that the factors in Connell are neither exclusive nor hyper-technical. It turns on the facts of each case specifically. The fact that it turns on the facts of each case specifically shows that it's not a rigid test, shows that it must be by a trier of fact. In that case, cohabitation was sporadic and not continuous enough. In Pennington, there was a refusal to marry coupled with her insistence on marrying somebody else. The claimant shows some living expenses, but not sufficient to show. We don't have any of that here. Why they're materially different is we cohabitated in the house for around a year using the RV only because of the delayed ADA accommodations. And what, I won't say man, because I don't want to seem sexist, what person in a relationship doesn't make promises that they're going to fix up something and do something for the other person and then let them down. We have shared household expenses under the Amazon. We have all of that. All of this they handled together. It shows mutual intent. The fact is this is where she thought she was going to die. He thought she was going to die there as well. There's, the respondents, I've already talked about the intimacy. That's not there. The fact that they're trying to make it seem like she was on a separate property, so it doesn't count. Where'd she go to the bathroom? She went to the bathroom inside the house. She took baths inside the house. Her food was inside the house. There was no heat. There was no electricity out to the RV. She literally only went out there because she needed ADA accommodation because she was going through chemotherapy. The fact is that everything about this, his anger, his change, what landlord would get angry about their tenant kissing somebody at a bar? No landlord would do that. The party's intent is discerned from their actions and words, not by the labels. I think the actions and words here are really clear. The SSD benefits an alleged fraud. The fact is that's not true. She lost it because she got an inheritance. She wasn't committing fraud. He's attempting to accuse her of losing it so that there's a credibility contest. But again, it's irrelevant.
Yeah, we're gonna have to wrap up.
Okay.
I've tried to give each side similar time, and you're already over by about 5 minutes.
The fact is that there is no way this can be a summary judgment. There is no way this can be frivolous, because if it's frivolous, it has to all be frivolous. And anyone who reads those text messages clearly would believe they're from a relationship that's gone sour, not from what they're saying it is. Under Connell, Byerly, ambiguity, and Muridan, this has to go to trial because there's questions. Essentially, matters of the mind differ. And she didn't leave her stuff there. She went to visit her sister, and her stuff was essentially kept from her. Her safe was in the house. What tenant would put their safe inside a house they didn't live in? So I'd ask Your Honor to deny the summary judgment and to deny any sanctions or fees.
Ms. Baldwin.
I'll just take 2 minutes, Your Honor. It has to be a dispute of a material fact. And counsel works really hard to try to change what the facts are, or kind of flavor them differently. But the reality is the facts are largely based on her own words. She just doesn't like what she said about a year ago. Counsel says, I hang my whole argument on these parties having sexual intimacy. It's not in my brief. It wasn't in my argument. So no, I don't. The word cohabitate means literally to live together in a single dwelling. You can't just say do life together. That's what we say about friends. That's what we say about churches. That's what we say about school kids, that they're doing life together. That doesn't make a marriage. The duration is only 17 months, which they admit, and that is a factor and is to be considered under the law. The purpose in this case, both adamantly opposed that this was a marriage-like relationship. By multiple people testify to this, that they both adamantly opposed that this was marriage-like or that they were a couple. And that's the whole point of a CIR, is that you are marriage-like and you are a couple. There aren't pooled resources. You have a text message about utilities, but 0 utilities in her name. So she never did that. She never said, I'm going to put those in my name. So she then was also saying, no, I'm not going to do that. This isn't marriage-like. The purpose, again, both of these folks deny to the public and to everyone else that this was marriage-like. It wasn't exclusive, which again, we see, and that's a factor to be considered. She actually did pay rent. So if this wasn't a sort of expectation, she would never have actually paid it. And all 3 of us have been on the UD docket, and we know that many mom and pop landlords are not great and are significantly inappropriate with their paperwork and whatnot. These were folks that were like, hey, this is going to work for me. This is going to work for you. You're going to pay a little bit of my bills, and that's going to work out great. Watching TV together does not make a CIR. So, and again, there's no evidence this was a joint Amazon account. It's to the opposite. All she shows is that there were purchases, and my client says, yeah, I did that, and I did that with other people too. So we just do not have the hallmarks here based on the petitioner's own declarations. Those are the material, genuine facts that we're looking at, and those can't be disputed because they're her words. So because of that, we're asking the court to grant summary judgment and then make the frivolous finding as well.
Okay. Thank you both. What I'm going to do is get you my written decision Friday. I just assume folks will want some specific findings of fact if either party wants it reviewed. So I will get that out. You will have it before probably noon on Friday. And
That's very quick. Thank you.
I always put that on the record so it holds me accountable to getting it done. Otherwise it sits sometimes. So yep. I appreciate everyone's time. I know the parties are online as well, and I appreciate your time and patience today.
All right. Thank you.
Okay.
Thank
Yep.
you. Thank you.